Fowler, the president of the Apartment Owners Association, and it's so good to have you with us today. And we are streaming live here. The problem is we had the attorney that we're having speak today. Well, he had court happen, and so he was unable to make it at the time that we had arranged, but made time for it now. So here we are, we're live. This is about San Diego. We're going to be covering 5 of the top questions that AOA members are asking these days in San Diego County. And we're going to cover Chula Vista and just recently passed, well, today I think, tenant protections that were passed and a little bit on that. And so we're going to get started here. And really, our goal for you is that you'd be the most successful that you possibly could be in your rental business. And so we're trying to provide you the information and the tools that you need to do that easily, more easily. It's not easy, is it? They call it passive income, but it's not. Easily and with enjoyment. And so we want that for you. We want it to be efficient. We want to maximize your investments just with the information and the tools that we're able to provide for you. If you're not an AOA member, just know that there's a 100% money back guarantee in your first year. So we definitely go to aoausa.com and join. And just to give a couple updates on what's going on, we had a couple updates in the magazine. You'll see this here. Down at the bottom, we have a way for you to just find out what's going on. There's a little, it'll tell you exactly which page it's on, where the seminars are, the live streams, things like that, other information. So check out that new area down there when you're looking for events. That'll be your go-to page. It's not always going to be on the back of the magazine. So that's something that's new that we've been doing. Another thing that's new is there's a new search engine that has all of the AOA contractors and vendors in it. And what's great about it is that it goes by your location. So it'll ask you for your location. You don't have to put it in, but you'll just allow it to. And then it will give you results based on where you're at. So if you were to type in attorney and you're in San Diego, you're going to see our speaker today. You're going to see his company there. Or if it's a plumber, you'll see the one that's closest to you first. So it's going to go in geographical order. Very cool. And also, another thing that we did is we created a playlist for the videos that are specific to San Diego on the YouTube channel. So if you go to YouTube, AOA USA, if you click on the playlist tab there, you're going to see that there's a whole playlist of things that are just San Diego. Another San Diego thing that we did is we created a San Diego branch, like a little micro website. And if you go on the Contact Us page, there's a link to that, and it has the businesses listed. It has articles that are specific to San Diego. And anyway, so those are all things that we've been doing, just specific to San Diego. We know that all of you love Victoria. And speaking of San Diego, we did have a great in-person seminar with Terry Moore and how to build wealth in a recession. Just had a lot of great feedback about that. And if you missed that one, don't miss the next one. The next one's coming up March 7th, and we're going to have kind of like a political action meeting where no matter where you're from in San Diego County, we can come together and just talk about what we can do to protect our property rights, because things are getting pretty crazy, as you know. And then also coming up on the live stream, March 2nd, we have one. It's the third part in a series about building code violations. This is all California, so it really applies to everybody, but building code violations, the ones that are common for people who own rental property. And then, of course, next month, around the same time, March 23rd, we're going to have another one of these Q&A sessions with our speaker. And so anyway, we're going to get to it now. The speaker that we have, we're going to have a Q&A time, and then you're definitely going to be able to ask questions as well. But just know that this is about San Diego County, And our speaker today is an attorney that's got 30 years of experience, 20 years of experience, and he will know California state law, and he's going to know San Diego County law. So if you have a question about LA City, he's not going to have an answer for you. And so please just be aware of what he's doing. But he's been a resident of San Diego since 1970. He graduated from the University of San Diego, and he's been an adjunct professor there, I believe, for 21 years. Is that right? And he's done over 5,000 unlawful detainer cases. His firm has also assisted and advised clients with their real estate and loan transactions, and has assisted clients in over $65 million of real estate transactions and loan approvals. So we're going to get started here. It's my pleasure to introduce to you Franco Simone. All right. So, today we had some things come up in Chula Vista, didn't we?
Yes.
So they just enacted the CVM 9.65. So there's a lot of different things that are involved there. And I know there's a notice that we already have up on our website for people in Chula Vista, because they're going to have to let everybody know about it. But can you tell us about it?
Sure. Actually, it's called the Residential Tenant Protection Ordinance in the city of Chula Vista, in the county of San Diego. It actually passed on December 6, 2022. It's supposed to take effect March 1st, 2023. So this is a pretty strict ordinance giving tenants certain protections, and which means that the landlord has to do a lot of other things. It puts a lot more duties, responsibilities on part of the landlord in order to manage his rental business. But there is 2 notice requirements as part of this law. The first notice that you should give for tenants that are currently existing should be by March 1st, 2023, is a notice of exemption. So if you fall into one of the items that exempts you from this law, you need to serve that notice, that particular language, onto your tenants. After March 1st, 2023, that notice needs to be part of your rental agreement if you are exempt from this regulation. Then there's another notice, which, if the law does apply to you, a second notice that needs to be given to everybody on March 1st, 2023, is a notice basically saying that the rent is subject to certain limitations. And so that language needs to be given to all of your tenants if the law applies to you by March 1st, 2023 as well. So one's an exemption notice, and the other one is just a notice stating if the law does apply to you, hey, by the way, tenant, there's certain restrictions on rent increases.
Right. And so that the law applying, is that basically people who have 3 units or more, just broadly speaking? I know it's a little more complicated than that, but
it excludes certain things. One of them is if the owner's living in a home and he's not renting out more than 2 bedrooms in that home, they're exempt. If there happens to be, let's say, a duplex within one structure, so you have a 2 units connected, they have to be connected. It can't be separated. You can't have an ADU, an additional dwelling unit, and a house that are separate. But if they're connected, it's a duplex, and you live, and the owner lives in one of the units, you're exempt. And then also, if it's a single-family home, and this kind of mirrors the state law, if it's a single-family home or condo, so it's just one building, and the owner's not a real estate trust or a corporation or an LLC that has a member that's a corporation, and it's not a mobile home park, then that's exempt as well. So those are, and then on top of that, you have transitory or hotel occupancy. But if you fall in one of those exceptions, then you need to serve that exemption notice by March 1st and have it included in any new leases, rental agreements that you enter into after March 1st, 2023.
Right. All that in Chula Vista. How do you think that's going to impact everything?
Well,
in Chula Vista?
The Chula Vista law is more strict than the state law. They actually go the extra mile. So besides adding, when you can kick out people, when they're at fault and when they're not at fault. It also deals with certain actions that the landlord cannot harass or retaliate against a tenant. There's certain things they can't do. It also basically requires the owner to do certain things. If they fail, and what I don't like about this regulation is if an owner fails to do something under this ordinance, they could be subject to anywhere between $2,000 to $5,000 penalty per violation per day. So if you have 2 violations and you do it for 10 days and the violation is $5,000 per day, that's $10,000 per day times 10 days. That's $100,000 for failing to abide by this new ordinance. And unfortunately, with the new ordinance, it also has an attorney's fees clause, which means if the tenant attorney sues you and you lose, you're also on the hook for their attorney's fees. The other thing that this adds, it basically states in addition, and it expands the relocation benefits to the tenant. And it greatly expands it as you know, under state law currently, you're typically might have to give 1 or 2 months relocation benefits. Here, any relocation benefits that are required in the Chula Vista ordinance is going to be in addition to the state relocation benefits. So if the state requires you to pay 1 month, and then this regulation requires you to pay 6 months, you're going to pay 7 months relocation benefits. Or if this ordinance requires you to pay, 90 days, so 90 plus 1 month, you're up to 4 months now. So that's another thing which is, pretty burdensome on the landlord. And the final thing, the state law has an exemption. If you build new units and they're less than 15 years old, the state law does not apply to you. Under the Chula Vista ordinance, I don't see that exemption in this ordinance. So what does that mean? If you build new units, you're going to be subject to this very strict ordinance. And unfortunately, I think that might have, a detrimental effect on new units being developed in the city of Chula Vista.
Well, it looks like they just took the welcome sign out of the ground. They just pulled it out and kind of stamped on it.
Yeah, I think so. I mean, as you know, there's a lot of mom and pop rental owners out there who've been owning properties for years. And, they're just not the sophisticated owners of maybe 10,000 units. They may owe a couple, a building here, a building there, maybe a couple homes, and they're just not going to be able to be up to speed with these laws. And what I fear is, it's going to drive these type of owners out of the market. And these are the type of owners that typically own the older buildings that have the lower rents. And if we force these type of owners out of the market and they get gobbled up by the larger landlords have no real incentive to try to keep the rents down or have that. Usually
Right.
Mom and pop owners are the ones who are more understanding, might not raise the rents every year, are willing to let the tenants do what they need to do and work more with the tenants. But this law is going to basically drive out, unfortunately, these mom and pop owners that are providing the low income housing.
Right. And we're seeing it all over the state. And it's, another way you could say it, they're squeezing out the middle. They're squeezing them out. And when you get bigger companies running everything, like if we were to take a survey today and look at the big operators and count how many units they have that are below market on the rent, and then take everybody else and count the number of units that are below market rent. I mean, it's going to be just a couple units for the big guys and the mom and pops. So many of them are below market rent. And it's incredible that they're kicking out the very people that they need so desperately.
Yes, it's true. And, if some mom and pop people only have a couple units or a couple homes or 10 units, they just don't have the ability to take on the additional expense of making sure that they're abiding by this new ordinance. For a company that might have 5 or 10,000 units, paying a tenant 3-4 months relocation benefit might work. But if you have a mom and pop person who might have 3 homes and forcing them to say, well, you're not going to collect rent for 6 months, it's going to be a huge burden on them. And so I think a lot of times when the state or cities enter into these regulations, they don't take into account there's a cost to it. Not only the relocation benefit, but there's a legal cost. I need to hire an attorney now to help me understand what I need to do, what I don't need to do. And if I don't do that, am I going to be subject now to a lawsuit where some tenant attorney is going to sue me because I failed to give a notice by the proper date, and I'm subject to $2,000 a day. I have to hire an attorney now to fight that battle, and maybe end up paying the attorney something just to drop the lawsuit. But that something might be $5,000-$10,000 because these new ordinances are being passed. As you know, there's been, since COVID hit, there's been new federal laws, new state laws, new county laws, new city laws, new court rules, and not just one new law. It might be multiple laws on different levels. And me being an attorney with 30 years experience, we have difficulty trying to keep everything together. I can't imagine someone out there who's maybe owned property for a very long time try to get all this together to understand exactly what they need to do with all of these new laws. And as you can imagine, a lot of these laws were, quickly formulated and passed, so they conflict with each other. It's very unclear what they want the landlord to do. So even if you wanted to, hey, I want to follow the law, sometimes it's unclear what the law is and what law should apply, because everybody kind of made up new laws and they really contradict each other sometimes.
Right.
So
now,
I feel sorry for the mom and pops.
Right. And so, knowing our members, one of the questions that they would ask you is, well, is there a lawsuit? Are there any other lawsuits in the state perhaps that are trying to fight against these kinds of laws that have been passed and that you're aware of?
Well, I know during COVID, there was a couple lawsuits that were filed to try to overturn certain laws. And the problem with those cases are typically it takes years for a case to bubble up from Superior Court to the appellate court to maybe the state Supreme Court. So these laws sometimes came in, were only in effect for 3 months or a year, and then they quickly went away. Some laws still stuck around, but these laws, it just didn't behoove landlords to get together to try to fight them, because if they only lasted 3 months, there's no way that the courts are going to be able to handle it. Like I said, normally it would take 2, 3, 4, 5 years to determine what these laws are going to be. So the market still hasn't stabilized on what the laws are eventually going to look like. As you can see, Chula Vista just passed a new ordinance just last month. I'm sorry, in December, right? And the city of San Diego is looking at a new law. So we're still in flux. We still don't know what the final version of the law is going to be, of what landlords need to do. And it appears every year we have 1 or 2 new laws that they need to now adhere to. So, and that law might take precedence over a state law. And so if you start a suit and all of a sudden a city or a county passes a new law that makes the state law not applicable to you anymore, it just makes it difficult to figure out what you're required to do, what is a proper law, what is an illegitimate law. And there's a cost and expense to that to, try to take it all the way up. Because by the time you take it all the way up and you incur all that expense, it might end up, well, that law is no longer in effect, so we're really not going to deal with the issue anymore. So those are the issues that are going on right now. We're still in such flux. And I think once the law is kind of set and there isn't people changing it anymore, I think the courts will have more time to start entering decisions on these laws. So a lot of times when people call me or I talk to them about, well, what about this? What about that? My answer might be, I don't know. The court has never really decided this issue before. And so it takes a lawsuit to decide each one of these little issues. So let's say 2 laws conflict. I think this takes precedence, right? And this is why, but could a court down the line, 9 months from now, actually have a case and they say, well, no, it doesn't, and change what we believe. So I can review the laws. I can give my best opinion that I can come up with on what it says and what it means. But until there's cases out there, not only at superior court level, but the appellate level, actually describing what it means to give attorneys some guidance, it's a crapshoot.
Right. And guys, if you're specifically for Chula Vista, if you're watching this and you know people who live in Chula Vista or have rental property in Chula Vista, send this to them because they really could cost them a real load of money if they don't know this. And I'll move on. Just when it comes to eviction cases, our members are asking, what are cases that are most likely that landlords are going to win or ones that are least likely? So before they even call you, usually they call you and ask you, hey, do I have a case here? Maybe you could save some people a call or or encourage people to call you. Tell us
Right.
what's a go and what's not.
Um, uh, the cases that where the tenants are at fault are probably more easy to win. Let's say they like at fault could mean they failed to pay the rent. They're illegally subletting the units. They're causing a disturbance, a nuisance. It could be any type of breach of the lease. If we can show those type of breaches, and it's not too difficult evidence-wise to show it, like an easier case is failure to pay rent. He failed to pay rent for February. Okay, great. We can show that he didn't pay it. Then it would shift over to the tenant to show, yes, I did actually pay it, right? As opposed to, you know what, the the tenant has an illegal guest or sublet the property. Well, if we end up in an eviction, I need to prove that there's an actual person in there. Now, the tenant might deny, well, no, I don't have anybody in there. And of course, let's say the property manager goes, well, no, I've seen this person there for 4 months. He sleeps there. I see him in the morning. I see him late at night. But I have to present evidence because the other side might say, no, he's just a guest. No, he doesn't really live here. And so that becomes a little bit more difficult. So the easier to prove the disturbance, the better, and the more likelihood we're going to win. The no fault can be, sometimes difficult. So let's say no fault, you want to remodel the unit. And as you know, in the city of San Diego, they have their own ordinance, and it has to be a substantial remodel, and you have to pull all the permits prior to serving the notice. And so we have to show all those things. Look, it is a substantial, and prove that it's a substantial remodel. Look, we pulled all the permits and proved that we've pulled all the necessary permits and kind of jump through a bunch of hoops. So each time we need to jump through a hoop, it becomes more difficult to prove up your case.
All right. Okay, here we go. Question number 2. Can multifamily units under AB 1482 raise the rent CPI plus 5% and charge extra for utilities if the utilities have always been part of the rent up until that point?
Okay, this is a great question. And the answer is, I don't know. The 1482 is silent on whether or not you can do this. So when you're looking at a law, you take a look at it and say, okay, well, the rent can't increase more than 5% plus CPI if the law applies to you and you're not exempt. Okay, then the question becomes is, if I now change the rental agreement, do a notice of change of terms of tenancy, and basically say, hey, tenant, from now on, you're paying the electrical bill. Is that payment of the electrical bill going to be considered quote unquote rent? So the argument would be on the landlord side is, well, Your Honor, it's not rent. It's actually covering the cost of electricity. So it's to cover a cost for the premises. Rent is something different. Now, obviously, the tenant's attorney is going to say, well, Your Honor, it doesn't really matter, right? Before let's say the tenant was paying $1,500 a month, and now they're subject to $100 a month in an electrical bill, let's say, and $100 just gets added to the $1,500, becomes $1,600, and equivalently, they're now paying $1,600 for this unit, where before they weren't. So it's all going to come down to the definition of what the judge is going to say is rent, right? And the judge can go either way, right? An appellate judge can say, you know what? Rent is rent, and this utility charge, I'm going to view it as a utility charge, which is not rent. But I can easily see a landlord saying a judge saying the opposite, right? So what I typically tell my client is it's unclear. I don't know. I suspect if in your rental agreement you had something that says the rent is $1,500 plus we're charging you $100 for electricity, and you specifically say that, then I think it might, and for a total of $1,600, I think it might be tough to say, you know what, now you're going to pay you utility bill, right? Mm-hmm. Because you considered your utility part of the rent. But if your lease agreement is silent, let's say, hey, your rent is $1,500 and I'm going to pay the utility, and that's all it says. and then you serve a notice to change the terms of tenancy saying, look, from now on, you're going to pay utilities, I think you might have a better case. But that being said, I don't know. It's silent.
Right.
If the landlord wants to try it, they can try it. And if it gets to a point where we have to litigate it, it's going to be up to the judge to determine, is this really quote unquote rent or not? Like, back in like an example of, well, what's rent, what's not rent? Under Section 8, which is federal subsidized properties, there was a case out there that basically said, even though Section 8 was covering a portion of the tenant's rent as a subsidy, right? So let's say the Section 8 was paying the landlord $1,000 a month, and the tenant's portion was only $500. There's a case out there that basically said that Section 8's portion of the rent is not considered rent. Okay, so if the landlord served a 3-day notice to pay rent or quit on the tenant for $500 for their portion, they can still accept Section 8 payments because it's not rent. So there, in that case, the court determined, even though it is a portion of the total rent that's paid, those payments weren't considered rent. So the same thing could happen with utility charges. I don't know, or they might not.
Great answer. Great answer. All right, and then the next one, it's similar. In multifamily units under AB 1482, charge an additional $100 a month or 25% as stated in the AOA lease for additional tenants and raise it to 10%. So it's yet just another nuance to this thing, that's AB 1482.
Right. So the problem when legislatures pass certain laws, they don't think of all the possible outcomes that could happen. And this is a possible outcome that could happen, right? The landlord wants another person, well, maybe the landlord and the tenant would want another tenant to reside in a unit. Everybody's on board, and sure, look, I'll accept another person because there's going to be additional wear and tear, additional water that's going to be used, maybe utility usage is going to go up. So you pay me an extra $100 and you can bring in this tenant. That sounds all nice and reasonable. And prior to 1482, that was completely legal because two parties are free to contract with each other. But whenever a law like this is passed, you're interfering with the relationship between the landlord and tenant and what they can contract for and what they can't. Now, same thing as before, 1482 is silent on this, right? I don't know if the court's going to say, well, look, you agreed to another person, but this extra $100 is a rent increase, an improper rent increase, right? So if the judge views this as an improper rent increase, you're going to lose. But if the judge says, you know what, I'm going to view this as a new tenancy, right, where you're asking for a new person to come in, and I'm not going to view this as a rent increase because both sides are receiving some type of benefit, then it's going to be okay. I think under the law, I think they would probably not say it's okay. So I think the law would view that as a rent increase on top, and it would be illegal. That being said, the opposite is true as well. So let's say you rent it out to one person and he's been there for a couple of years, and now he says, look, I want to have a new person come in. The landlord can say, no, I don't want to rent to someone else. I rent it only to one person. And even if you pay me extra money, I don't want the extra money. You can only stay here for one person. If that doesn't work for you, you need to leave. So the reverse kind of helps the landlord there and say basically no. Now, that being said, you don't want to open up yourself to discrimination lawsuit where you're discriminating against families. Let's say there's two tenants, a husband and wife, and they have a child. Obviously, that child would be considered another occupant / tenant for the unit, and the landlord can't say, well, I don't think they'll be able to say. And again, doesn't explicitly outline in any law, but landlord wouldn't be able to say, well, I rented out to two people. Now you have a child. You can't have the child there. I think in that case, you're going to be basically viewed as discriminating against families. I wouldn't recommend that. But if you don't have that situation, then yes, I think it's going to be considered a rent increase. Again, I don't know. The law doesn't cover it, but the way I think the court's going to view it, I think they'll view it as an illegal rent increase.
Great. All right. We're getting through these. Number 4, we got one more after this. It's really number 5, but when is the new San Diego ordinance expected to take effect, and will it be retroactive?
Okay, the new San Diego ordinance, I believe it just came out. The proposed ordinance just came out on December 6, 2022. So it's the proposed ordinance. So it hasn't been passed yet. I don't know when it's going to get passed and if it's going to get passed. Okay, so It basically adds more restrictions on the landlord beyond the current San Diego ordinance that's currently in effect since 2004. And so they're trying to make it more restrictive, kind of similar to the Chula Vista law that they just passed. But at this point, it's just proposed. Same thing in this proposal, I don't see any exemption for new construction, meaning buildings less than 15 years old. If it doesn't have that exemption, I suspect that developers aren't going to build as many units as they would have if there was some type of exemption there. But it does increase the protections, the relocation benefits that a landlord needs to do. It restricts what they can and can't do with their tenancies. It starts the protections a lot sooner. So under the current San Diego ordinance, the protections don't kick in until the second year. So the new ordinance, if it does pass, it would kick in as soon as the tenant moves in. Like I said, it increases the amount of relocation benefits from typically 1 month to about 3 months. It reduces certain causes that you're able to kick people out for. So you won't be able to kick out people for any illegal use of the premises without a conviction. So let's say your tenant's doing drugs, selling drugs. Well, you wouldn't be able to kick them out because they're illegally using the premises to sell drugs unless the police arrest them, they get convicted for drug use. I don't know how that's going to help other tenants that are subject to a tenant selling drugs, and makes it impossible for a landlord to basically wait and rely on the police and to basically catch these people, take them to court, convict them. That might take 1 or 2 years. In the meantime, everybody's going to be subjected to a person that potentially selling drugs, people going over there all day and all night, knocking on the door, trying to collect stuff. And also the other cause that they withdraw is if the tenant refused to sign a new lease, that won't be a reason anymore to kick out people. So it becomes a lot more, difficult for the San Diego. So hopefully they'll modify this. We don't have the final language yet on what it's going to be. But then again, what the city of San Diego is trying to do, like the city of Chula Vista, is fix all the problems with affordable housing on the backs, unfortunately, of the landlords. That's okay to a certain extent. But if you keep pushing it to further and further along, what you're eventually going to end up happening is restricting the amount of new units that are being built. It's also going to restrict housing providers' willingness to keep their units, in good shape. Because in order to remodel a unit now, you're making it more and more costly and more expensive to do. So it might stop people from just doing that. And we're going to be basically in a situation where we're in San Francisco and New York, where a lot of units that are under rent control don't get fixed up, become really bad, and nobody builds new lower income units. And that's the exact opposite of what the city should be doing. And so I think they're kind of shooting themselves in the foot by putting all these new restrictions on housing providers, because they're the ones that are providing housing. And so you're punishing the actual people that are providing the product that you say you desperately need. What the city should be doing, and the state and the federal government, is encouraging development. I'm all for lowering restrictions on what can be built, higher density, so you can build more units on a property. But by putting so many restrictions on kicking out people when they're at fault, or you just want to renovate your unit, it's just going to lead to a lesser housing stocks and lesser units. I think in 2022, the city of San Diego built about 5,000 new units in the city, and I think they needed like 100,000 units to catch up with things. So already with the restrictions prior to these new regulations, we're down to 5,000. That number could go down to 0 because new developers could be like, I don't want to build new units anymore. I'd rather build office building, industrial. And so that's the problem that I think the city and the state's going to eventually realize in about 5, 6, 7, 10 years, that why aren't people building anymore? Why are rents still going through the roof? And part of it is, it's just become so costly to adhere to all these new regulations that the units don't get built. The units are become less habitable because they're not being renovated. And like I said, we end up with a housing stock like New York that are still on rent control, that are just in dilapidated situations, or up in San Francisco where they're at the highest rents. The highest rents, the two cities that have the most regulations on rent, have the highest and hardest rent controls are San Francisco and New York. And the two cities that have the highest rents in the United States is San Francisco and New York. Is that a coincidence? Coincidence? I don't think so. So that's just my opinion, but hopefully I answered that question.
Yeah, okay, here's the last question. What is the biggest threat to San Diego residential landlords based on upcoming city or county renter protections?
The biggest threat is they're going to make it more and more difficult for you to get rid of troubled tenants. And that's a big concern because during COVID, when they really strictly reduced when you can kick out people, the courts were closed. You know, there were situations where a tenant was being very disruptive, was threatening other tenants, was being belligerent, and you know, we couldn't kick them out for a time period. Or it made it really difficult for us to try to kick them out. The same thing, I think the biggest restriction, I think, is there's no exemption for new construction, right? So, you know, if you're a developer and you were thinking about building 20, 30 units, you know, do you want to take that on if you know as soon as you do that, and as soon as somebody moves in and they become an issue, they're not paying their rent, or they're causing a nuisance or something like that, and you just have to hump through so many hoops that it just becomes very difficult to kick them out. Currently, because of these new laws and because of the court system and what's going through, in the past, prior to COVID, it would typically take about 2 to 3 months to do an eviction. So that gives some flexibility to the rental market. So if troubled tenants were removed, then new tenants could find new places. Now we're running about 8, 9, 10 months to the place back. And so landlords are eating 8, 9, 10 months, if not more, of unpaid rent. They can only sustain that for so long. And so that makes the rental market more rigid. So this person that should have been out because let's say they're causing a disturbance is there for another 10 months. It affects all the other tenants that are around them. And that doesn't free up a unit for another person that's thinking about moving to San Diego or move to different areas to find a new unit because it's not available anymore. So what's the consequence of that? There's less units available for people to move into, which just makes the rents go even higher. You know, and somebody's not been paying rents for 10 months. You know, in the past, they might have just said, you know what, I can't afford San Diego anymore. I'm going to move to Phoenix. I'm going to move to Albuquerque or somewhere else that was more cheap. They might decide, you know what, I'm going to stay here for 10 months, not pay rent, and eventually I'll move to another city. But then during that 10 months, that unit's not available for someone else to move into. So all these have an effect of restricting the units available. The vacancy is extremely tight now, and I think part of it is because it's taking so long to remove certain tenants. And so, you know, the rents are going to keep spiking, unfortunately.
Yeah. Yeah, I agree with you 100% on that. I was in a city council meeting a couple of weeks ago, and I asked them the question, you know, it's a public comment time, but I asked them, do you want to control more units or do you want to create more? Which do you want? Because you can't do both. That was one of the questions I asked him. And then another one, you know, how do you want to create those units? Are you wanting it to be all this affordable housing that you create? And it's like, have we forgotten why public housing failed? How bad it was? It's like we forgot that the whole Section 8 program was created because public housing was so horrible.
That's exactly, yeah. What the city should be doing is using the funds that they have to actually pay rent in units for people. Sort of like Section 8, right? So the public housing didn't work. They stay away with it. They did a study years ago and said, well, what's the best way we can do this without altering the market forces? And that was basically, we just subsidize people to live in units. When you subsidize people living in units, right? The landlord gets paid their rent so they can make sure they maintain the units. Also, it makes sense for developers to build new units because they can get market rents for them because the tenant will pay their portion. Section 8 will pay the difference, but it's market rent. By basically adding all these restrictions, they're going down the path of, well, we're going to kill any private sector building of homes because we're basically going to enter all these laws, which doesn't make it beneficial for developer to develop, which is basically the next step is going to drive, well, if the developers aren't building homes, then that means the state or the federal government has to. And all of a sudden you're building projects again, like you did in the 60s and 70s, that just became a mess. The worst builder in the world is the federal government, the state government. They're not set up to build units. I just read recently, in Los Angeles, I think they spent over $1 million to build one unit, affordable housing unit, and it took years to get it built. So that's not where you want the new housing stock to come from. And unfortunately, all these laws is killing the private sector building, will kill the private sector building. And it's going to force that eventually people are like, well, there's no units being built. State, federal government, let's build 200 units there. It'll cost us $1 billion, where a private developer might have done it for 100 million, right? And it'll take us 10 years to build them, where a private developer might have done it in 2, 3, 4 years. So, and in the meantime, what's going to happen? Unfortunately, there's going to be less affordable housing. There's going to be more homeless because they're basically attacking the providers, as opposed to they should be using the money. Hey, if somebody gets kicked out of a unit, let's provide these funds to provide them somewhere to move somewhere else, even if it's temporary housing, right? Until they can find another unit. Let's streamline the process to remove people, make it fair. I'm not saying not make it fair, but make it fair, have the legal protections. But then, add some flexibility back to the rental market so it frees up these units for people that really need them.
Right. Absolutely. Yeah. Right there with you, and so, yeah, public housing doesn't work. The other one, we have a high profile thing here in LA, and it's called the Skid Row Trust, I believe. They have about 2,000 units. They bought up a lot of stuff from mom and pops. And then it was so horrible that they had to start buying new units and building new units because the expenses on the older buildings were just running them in the red so bad. They run yearly. They have they're negative in the red, 14 million at least every year on 2,000 units. That's negative $7,000 per unit. And this is like the flagship. This is the model that everybody's looking at. So, just looking at that, saying they're pumping all kinds of money into this. It's, this nonprofit housing thing, it's not working. Public housing isn't working. But that's where our officials are leading us. And it's just like, hey guys, let's call a timeout. Let's think about what's really working. And I couldn't agree with you more. And I hope that people can come out to that political action roundtable or time where we can kind of get together and see what we can do. And anyway, if you have a question, now would be the right time to put it in the chat. I know this was kind of impromptu, so we probably don't have a huge audience at all watching when we didn't plan it. But if there's anything you guys could throw a question in, and thank you so much for your time. And you just take care of the members so well when they give you a call. I know that you take a question and you don't charge, right, for one question, and then after that you kind of get into
we AOA members a free 10-15 minute consultation. Typically it's usually general type questions. As we get more involved in things where we're drafting notices or filing a lawsuit, obviously we have to charge for that. But I'd rather have the owners know what the law is and do it right from the beginning, because it does solve a lot of problems and it doesn't waste a lot of time. So I don't have a problem talking to people, educating them real quick about what they need to do so they can get over the first initial steps that they need to do if they have to start an eviction or handle some other landlord-tenant issue.
Well, great. Well, thank you so much. Guys, just remember those different events coming up. Here, let me see. What were those again? Yes, March 7th. Will that be that in person? And hopefully you'll be able to attend. And then March 2nd, the building code violation thing, that's just on our radar because there's so much litigation. And one of the easiest ways for a tenant to get out of an eviction is citing a building code violation. Therefore, it's something that it's content that we're trying to give to you guys. And anyway, we'll see you in a month for sure for the
Yes.
5-question deal that we'll do. And guys, check out his legal Q&A, in the AOA magazine. He's writing that every month for San Diego. Check it out. And again, thank you, everybody. And thank you, Franco, Simone, so much. We appreciate it.
Thank you. I appreciate everything AOA does to help, get out what landlords need to do out there. So you're a big help. You're a big assistance to all the deal owners out there. So thanks for your help as well.
Okay, thank you. Okay,
Thank
see you later, everybody.